All right. So again, thanks for having us. Sorry we're late. My name is Alberto Roldan. I'm an outreach coordinator at the Department of Consumer Affairs, Office of Labor Policy and Standards. So David and I were going to sit here and briefly describe to you what freelance isn't free, the act itself, some of the background, how you guys may use it to protect yourselves and get paid on time. So we're going to cover. So we're going to test what our office is, the law itself, your rights under the act, and save time for questions. So the Office of Labor Policy and Standards was founded in 2015 and is housed in the Department of Consumer Affairs. Essentially, it's the central worker hub for workers in New York City, whether you're a freelancer, regular employee at retail, fast food, any type of establishment. So we're trying to, one, protect you as a worker, tell you what your rights are, but also pursuing future legislation that will give you more rights. A lot of this is done through original research from your complaints, general inquiries, our research that we do for our research staff, our paid care division. We just did a release or report on the paid care division, and in May, our 1 year anniversary of the freelance law, we're going to have another report to reflect we've learned since. So we do this through enforcement, outreach and education, which Dave and I do, our paid care division, which focuses on the issues of paid care workers, intake and referral, and research and advocacy. We have a team of attorneys, investigators, education specialists. We have strong collaboration with workers and unions and work organizations. So we cover paid sick leave, freelance and free, community benefits, fair work. We just came in with fast food and retail, so new law we cover now. So again, freelance and free came into effect May 15th of last year. It's the first of the kind in the country, only one that exists in the country. So before we go into the law itself, we have a strong retaliation and confidentiality portion of all of our laws. You can feel free to come into our office, file a complaint, and do it with confidence that one, will protect your identity when necessary. We'll reveal it without your permission, and also, any retaliation that does occur, it'll go against the employer and then benefit you as well because of fines for freelancers.
All right, so here's some statistics for you prior to the act. 71% of freelance workers had trouble collecting payment. Only 28% of them operated under written contracts, and about $6,000 was the average of annual unpaid income for freelance workers. Before this law, written contracts were not required. For non-payment, freelancers filed breach of contract claim, which was done through small claims court, but unfortunately, a lot of individuals were not properly prepared or educated into taking legal action representing themselves. So, unfortunately, a lot of them were never really fully able to recover the money that was owed to them. So again, there was few, if any, protections from retaliation. Now, depending on what industry you work in, so like let's say in the film industry, we've come to learn that in that industry, if you as a freelance worker exercise your rights under this law, there might be there's a chance that you will be blacklisted, which is a form of retaliation, which under this new law is protects you from retaliation. And we're going to get into that in a little bit. So now with this law, written contracts are required, timely payment. Now, if you don't sign a general formal written contract under this law, payment automatically becomes 30 days from the last day that you completed the work. Freedom from retaliation, of course. You have a right to file a complaint through our office. And you have a right to sue for any violations. And we're going to get into the damages and penalties a little bit more towards the end. All right, so what are your rights under this law? So you have a right to a written contract, to be paid on time, freedom from retaliation. You have a freedom to file a complaint. You have a right to file a complaint. You have a right to sue for double damages and attorney fees through court. And again, right to legal services navigation. Legal services navigation is basically the information that we provide you with to prepare yourself to go to court. So another disclaimer, so we're not attorneys. We don't give legal advice. But if you do need legal assistance, we can provide you with referrals through a network that we created with other attorneys throughout the city that do practice labor law. And in some cases, they can represent you pro bono. All right. So, who is a freelance worker? Freelance worker is an independent contractor hired by a hiring party to provide services for compensation. General basics of it. You can operate as an LLC, you can operate as an S Corp, but it has to be a single person, or you have to operate as a single person LLC, single person S Corp. I've come to learn while administering this law that in certain industries, the hiring parties might ask you to operate as an LLC or an S Corp. And some individuals, if they're not aware, they've never even considered doing that. And so they ran into like payment disputes because the hiring party will refuse to pay you because you don't operate as a single corp or an LLC. You are covered by this law regardless of immigration status. And when you contact, or if you contact our office, immigration status is not an issue. We will file complaints or try to assist you wherever we can.
And we'll never ask you. We're not allowed to ask you, and we won't ever ask you. So.
Now, the only exception to the only workers that are excluded from this law are sales representatives, attorneys, licensed medical professionals, and any worker that was hired or returned by a government agency, whether it's local, federal, city. So this is a checklist that you can kind of use to see if you fit as, or if you qualify as a freelance worker. So, are you an individual worker, or in this case, single person, operate as a single person LLC? Were you hired as an independent contractor? The services that you provide are in exchange for compensation, and are you exempt as a worker? Are you an exempt worker as defined by the law? One of the issues that we've noticed is like misclassification. Misclassification is huge. So you might get hired or sign a contract that says that you're an independent contractor, or you will be out working as an independent contractor. But the relationship that you have with the hiring party, the employer, might actually constitute you as a traditional employee, in which case you're protected under other labor laws that New York City and New York State have. And in those cases, again, if you're unsure under which category you fall, you can reach out to us. We cannot make that determination, but we can refer you to the Department of Labor, provide you with their contact information, and then they will be able to provide you with that information. So who's the hiring party? So it can be an organization, an entity, other than local, state, federal, or foreign government that retains a freelance worker to provide services for compensation. Right, so you have a right to written contracts. So any work that is valued at $800 or more under this law, the hiring party is required to provide you with a written contract. Or you can create your own contract. And while negotiating with the hiring party, you can offer that and say, hey, this is how I operate, this is my contract. And you can have a look it over. And if you visit our website, we have model contracts that you can use to create your own contracts. And if you want to know more about that, you can reach out to us and we can provide with training or resources. Now let's say you do work for a hiring party. Let's say you do 4 jobs throughout the span of 120 days. If those 4 jobs are going to value at $800 or more, then that falls under this rule, in which case the hiring party has to provide you with a written contract. And these are the elements that make up the written contract. So there must be the name and mailing addresses of the worker and the hiring party, itemization of all services, value of the services provided, the rate and the method of compensation, and the pay date. Again, under this law, if a pay date is not indicated in a written contract, then it automatically becomes 30 days from the last day that you completed the work or the deliverables were met. So they must pay you for all the work. In certain cases, we've had hiring parties who refuse to pay a freelancer after the work was completed. They refused to pay the freelancer either the total amount that was owed to them because they weren't satisfied with the work that they did. Now, if you entered a contract with them and you read through the contract, and if you saw a clause, or if you read a clause that says, these are the standards for the work that we're hiring you to do. If you do not meet these standards, then we will not pay you full compensation, or we will pay you partial compensation. If you read that and you agree to that, then under the law, or by general contract law, you have to abide by those terms. If there isn't a clause in the contract that indicates that, and you complete the work and they say, no, well, you know what, we didn't like what you did, we're not going to pay you, that's illegal, and you can file a complaint through our office for that. That's non-payment. And again, also with the 30 days. If 30 days is not indicated in the contract, automatically 30 days. And also another thing, they cannot try to pay you for less than what you had originally agreed to work for. So if they say, well, you know what, we're having financial issues, how about we work out a deal where we pay you, $500 when you originally signed a contract that says I'm doing work for $1,000. Under this law, that's illegal. They cannot do that, and you can file a complaint for that.
We recommend you put everything of value in the contract, whether it's your tolls, your gas, your supplies, everything that goes into the job become a reality. Put that in that contract.
Right, and that becomes the value of the contract. Right, so contract value. Reasonable value of actual anticipated services, costs for supplies, and any other expenses. So like, let's say the job that you're doing might require travel expenses. You might have to, you're working remotely, you have to travel to this borough or this location or this site. You can include that as part of the contract. So that becomes the value of the contract, along with the original rate or fee that was agreed upon for the overall work.
So can I say that in the audience, I'm assuming because of who we are, that our people in the audience here will be writing their contracts and giving them to the person inside.
Yes, and again, we encourage everybody to either start to operate by operate as a business. Start issuing your own contracts. If you're working for a big company, if they issue contracts, that's fine. You may not have to provide your own form of contract. But if you're working with a company that does not, then we strongly recommend you to create your own contract. Make sure you protect yourself.
And we've had cases already where freelancer asks for the contract and they say, oh, we took away the job, no longer available. That's for retaliation, and we feel that we have a case for protection under our law. That's something that's not simple.
And we've actually, so just a little bit about that case. So the person was a photographer. She was contacted by the hiring party, which is just a big company, well-known company, and said, hey, we're looking for somebody to do a shoot for this date, for this rate. So the freelancer was like, okay, that's fine. I need to sign a contract, or I need to look over your contract. And their response was, well, we don't issue contracts to our freelance photographers. So the freelancer was baffled, and when she expressed her rights under this law, they said, well, you know what, we're going to go another route. That's a blatant form of retaliation. And the freelancer reached out to us. We, again, followed through with the complaint process. We reached out to the hiring party. I spoke to the director of human resources, and there was a bit of a misunderstanding between the freelancer and her point of contact. But ultimately, they agreed to pay the freelancer, even though they didn't offer her the job. they agreed to pay her the original amount, the original rate that they were going to hire her for, because of the fact that they knew that they messed up. Like, they knew that was retaliation. And when I spoke to them, I said, look, under this law, these are the provisions. What you did is a blatant form of retaliation. They acknowledged it, and they ended up paying the freelancer what they were going to pay her. So again, you got to protect yourselves. So what's retaliation? Adverse actions relating to perceived immigration status or work authorization, circumstantial or direct evidence, denial of work opportunity. Again, and this can consist of blacklisting or denying you future work. Like if you worked with a company in the past and you all of a sudden you exercise your rights under this law because they paid you late. Now in the future, when they would normally contact you for this type of work, you're no longer receiving these notifications from them, or they're not reaching out to you anymore. That can be a form of retaliation. And so if you feel like you are being retaliated against, feel free to reach out to us, and we can review everything. And if we do see that we find that it's a legitimate retaliation case, then yes, we can go ahead and process the complaint for you.
Question. Let's say I'm a freelancer and I go to work for a startup.
Mm-hmm.
And in the agreement, the startup says they're going to pay me so much money for how much I do. And I go to work and I start working, and maybe I'm there on my second day on the job, and they come and say, oh, our funding didn't come through. You have a choice to continue working for us and then we'll pay you later, or not.
No.
What would you do then as a freelancer? That's my question.
Well, so you can tell them, hey, look, listen, there's this law. These are what my rights are. These are my rights under this law. And if you wish to continue to engage in this type of practice, then I can go ahead and reach out to the Office of Labor Policy and Standards and file a complaint. Or we can avoid all of this and stick to the original agreement that was signed. Now, I do understand that in a lot of these industries, especially like in the arts and entertainment industries, if you've established a rapport with a hiring party, you don't want to ruin it. You don't want to burn that bridge because that's income or that's potential for future income for you. We get that. And so you might be hesitant to say, or you might be hesitant to exercise your rights under this law. It's totally fine. You can use this law as leverage. You can say, hey, listen, this law is out to protect me, and what you're doing is illegal. I want to continue working with you, but if you continue to engage in unethical practices, then I have no choice but to file a complaint under this law. So you can use leverage. You can use it as leverage.
I wonder if that'd be a good time for a new contract. If so-and-so is like, we don't have the money right now, we'll pay you later. Like, okay, when is later?
You
new
can
contract, new date,
Yeah, so you can request it, or actually no, we urge you to request everything in writing. So if they say, hey, listen, we might not have the funds immediately, we'd like to extend the pay date, that's fine if you're okay with it, but just make sure you get it in writing.
Yeah. Another thing we saw is some freelancers, they'll say, let's say the job's $1,000. They'll say, give me $500 at the start, and when I finish, the other $500 comes through. So that way, they say the job has issues, you have something in your pocket.
Right, or if you wish to end the relationship prematurely before you complete the work or fulfill the contract, you want to at least make sure that you get compensated for something. So requesting, some sort of, a percentage for the rates up front, that we recommend that you do that too, because we do see that it is common where, again, halfway through the job, oh, you know what, we don't wish to continue, we're not going to pay you because you didn't fulfill or complete the entire contract. So
yeah, it tends to keep them honest. They'll be like, you know what, I already paid you half the job, all right, finish the job for me, because I have to still pay you anyway. So it's kind of leverage in a way.
Oh, and then as waivers, also known as clauses in a contract. So if you see any kind of clause in a contract that would prohibit you from exercising your rights under this law, that waiver is, that clause is waived. This is null and void, basically, because this law forbids hiring parties from preventing you from exercising your rights. That's why it's also very, very, very important that you read contracts. Read any contract. If you don't understand it, and honestly, if you're not an attorney, chances that you're not going to understand most contracts. It's the language is very ambiguous, and so if you're not comfortable reading it, or if you're having trouble understanding it, then you can reach out to an attorney, or you can reach out to our office, and we can connect you with an attorney who can review the contract for you and explain it to you in full detail, so that way you know your rights and make sure that there isn't a clause in there that's going to, prevent you from getting paid. So it's very important that you read contracts. You have a right to file a complaint under this law. So you would file a complaint with us. Here's another thing. So we're not the Department of Labor. We're the Office of Labor Policy and Standards. Two different organizations, but we do work with the Department of Labor. And if it is an issue that the Department of Labor or that it falls within their jurisdiction and they have to step in and take care of it, then we can go ahead and provide you with connection to the Department of Labor. But that's another thing too that I noticed. A lot of people confuse us with the Department of Labor. We're not the Department of Labor. The Office of Labor Policy and Standards. So the statute of limitations to file a complaint under this law is 2 years from the date that the violation occurred. So again, if you didn't get paid in October of 2017, you have until October of 2019 to file a complaint through our office under this law. Okay, and then these, you can, our complaint forms are accessible at our website. You can download them, and then we will provide you with our email address where you can send these complaint forms. And this is the complaint process. So what's your name?
Thomas.
Thomas. Let's say you didn't get paid for a job that you completed, and you want to file a complaint. Call up the Office of Labor Policy Standards. Hey, my name is Thomas. I'm a freelance worker. I didn't get paid for the job that I completed, that I was supposed to get paid for. Okay, sure, no problem. Fill out the form, send it in along with any documents such as a written contract, invoices, or even emails where you had conversations with the hiring party. Go ahead, send it on over, Thomas. Boom. You send it over to me, I receive it, I review it, make sure everything is accurate. Then the next step, hey Thomas, I'm going to go ahead and send over the notice of complaint to the hiring party. The notice of complaint to the hiring party gets sent along with the documents that you provide and the complaint form. And they have 20 days from the day that they receive our notice of complaint to provide our office with a written response. Now, the written response can consist of an explanation to the situation as why they did not pay you, or their stance, like, oh well, we refuse to pay them because of this, this, and that. Whatever we receive, I'm going to go ahead and forward over to you, and say, now let's say they refuse to pay you. Say, hey Thomas, listen, this is what I received from the hiring party. Look it over. If you still want to dispute it, then I can go ahead and provide you with the information and prepare you so that you can go and dispute this through small claims court. Okay? Now, let's say they don't respond. They don't respond to our notice at all. They don't reach out to you after we sent the notice of complaint. That creates a rebuttable presumption. What that means now is under this law, you have a right to file a claim in either small claims or civil court, depending on the amount that is owed to you. And in the small claims court, you can represent yourself. You don't have to pay legal fees, attorney fees. You only pay a filing fee, which is anywhere from $15 to $20. What the rebuttable presumption does is it places the burden now on the hiring party to prove their case or to show proof as to why it is that they did not pay you, as opposed to the burden normally falling on you, the claimant. And so that basically what it's saying is like, okay, you're guilty, but now you have to prove your case. Now you have to show us why it is that you're not paying the freelancer, even though the contract that you both signed, agreed to, says that once the work is complete, the worker will be paid.
Okay.
Okay? All right. Now, again, we're not attorneys, so we can't give you legal advice, but we can tell you. So I visited all of the courts throughout the 5 boroughs: civil court, small claims court, and I've become very familiar with the court process, what to expect, what forms to fill out. So that I can provide you with all that information, but I can't give you my personal opinion and say, hey, listen, Thomas, I think you should, go ahead and sue them and then request this and that amount. I can't tell you that. By law, I'm not an attorney, so I can't provide you with that, and I can't go to court and represent you. Okay? But I can make sure that you're prepared so that when you do go to court, you know what it is, what to expect, and you know what you have to present to prove your case. Okay?
I'm sorry.
No, go ahead.
I think the unique thing about the law is when it comes to attorney fees, if you win your case, you don't have to pay them. The hiring party has to pay the attorney fees on your behalf. It's kind of an incentive to get representation on your behalf to really get you your contract and your fees. So it's something we feel is very fair.
Right.
Right.
So, before I get
Yeah, how long does this usually take? Like going to a final step?
so the court process,
Yeah.
or all right. So with the court process, you go into small claims court. Let's say you go into small claims court. You file a claim. They give you a court date a week after you filed. The court date is usually 30 days from the first day that you went in and filed, and the court process may take anywhere from a month to several months, depending on the hiring party, if they're going to continue to adjourn the case, or if they want to think about weigh their legal options. But I cannot guarantee you or tell you that you're going to go in there 1 month and in 1 month everything will be resolved. No, it might take a little bit of time, depending on the hiring party. But we do encourage you to stay on top of it, to follow through with it, because what we have found is that a lot of individuals, they'll start the process, and then halfway, later on down the line, and they're like, you know what, I don't have time for this. I'm tired. Forget it. I'm just going to forego this and I'll cut my losses. We get that, but we urge you to continue throughout the entire process. In some cases, you might only have to go to court once. So in other cases, you might have to go to court a couple of times. I just had a case last week where the freelancer went to court. The hiring party didn't show up. They received the decision. They ruled in their favor. So the freelancer won the case. So now they can start the collection process 30 days from the day that the decision was made, or the time from the date that they ruled in their favor. Questions before I go on? All right. So again, filing a lawsuit, going through through small claims court. Our navigation services will provide you with the information that you need. And you can come down to our office, we can sit down with you, we can review your documents, which would be your evidence. We would tell you, okay, this is what you need to take to court, this is what pertains to your argument, this is what might help strengthen your argument. So that way, when you do go to court, you're well prepared, you're not nervous. And one thing I have seen in court is that just the thought about going to court makes people nervous. To be honest. And then when I go down there and I see people in court, they're a nervous wreck. And I do get it, but if you're well prepared, that might help alleviate some of the nervousness. It might alleviate some of the anxiety. Because again, going to court is not fun. And nobody wants to go to court. But at least with our navigation service or navigation guide, you'll have the confidence to go in there and say, okay, I'm ready. I'm ready for this battle. Let's go forward with this. And again, the statute of limitations in court is also 2 years from the date that the violation took place. All right, so certain some courts are 1 year, but most courts are 2 years. So anywhere from 1 to 2 years. So in certain cases for non-payment, underpayment, or retaliation, it's 6 years from the date that the violation took place. Okay. So again, our legal service navigators or court navigators, we are trained to help you access the court. Court forms, templates, interpretation, translation resources. A lot of the courts throughout all the boroughs, they have like a law library. So if you want to go and use their facilities to kind of do some research either on the hiring party which you're suing, like if they have other legal cases pending, or if you want to use their facilities just to educate yourself about the law, they have these facilities available to you. And then again, if you feel more comfortable speaking to an attorney, we can help connect you to an attorney.
You must need to see that one or the other. You can't go to it. Either a letter or you go to court. You can't go as an court.
No, that's another thing too. So if you file let's say, Thomas, you call me up, you file a complaint, right? And then right after you get off the phone with me, you go straight to court and you file a claim in small claims court. Once you do that, you're basically you're removing us from the picture. So our jurisdiction, our complaint process it goes out the window, and now you just have to follow through with the court process. So essentially, what our complaint process is like the first step, and we hope is the only step to avoid going to court. I want to give you a rough estimate. About 90% of the complaints that we have sent out, 90% of them have received payment. Okay, so our complaint process, it's effective, and again, it's the first step in one, helping recover the money that is owed to you, but also the step before going to court, if it has to go to court. In most cases, 90% so far, our cases have, our freelancers have received payment after the hiring party received our notice of complaint. We've only had a handful of individuals that have had to go to court in order to collect. Okay. Now, these are the penalties for the violations. So if the hiring party refuses to refuses to offer you a written contract, it's $200. The penalty for that in court is $250. If they refuse to offer you a written contract and they violated another provision of the law, which was, let's say they didn't pay you on time on top of not giving you a contract, then the penalty for that is the value of the contract itself. So let's say the original amount that they owed you is $1,500. Under this law, if you win the case, now the judge can award you the value of the contract. So now you can collect $3,000 for their violations. Okay. Non-payment or underpayment, you can receive double damages. Again, injunctive relief, legal fees, attorney fees if you've had to hire an attorney. Retaliation, which is blacklisting, intimidation, harassment. That is the value of the contract for each retaliation violation. So let's say if you feel that you've been retaliated against and the hiring party has tried to bully you from attempting to collect what is owed, and on top of intimidating you, they've also blacklisted you or they've harassed you. Those are 3 violations. So now if you win the case, the value of the contract, let's say that the value of the contract, the work that you were supposed to get paid is $1,500. So now it's $1,500 for each one of these violations. So $4,500 right there. Okay? All right. So, in a nutshell, that is the freelance law. If you have any questions?
In this freelancing job, I am mostly complete with it, and I keep dodging we haven't done a contract,
Mm-hmm.
and I'm almost done with it, and we're gonna start a new project soon.
Mm-hmm.
But I'm not really sure how to press hey, I need a contract before I do any more work.
Well, you can say, you can say, hey, listen, before we move on to the next project, if you don't mind me asking, what's the value of the work?
It's $1,000 for the first project and $1,000 for the next.
Okay.
So I've been paid $500 for the first half of it.
Okay.
I'm just close to the other payment.
Okay.
They've been reasonable, except they're not very timely and they're not very structured.
Okay.
And they're not used to working with an artist since they're more business people than
Gotcha.
arts people.
But yeah, no, you can, the way you can phrase it is, hey, listen, I want to make sure that I'm protected, and I want to make sure that, all parties involved are protected. So before we start with the next project, I would like to sign some form of written contract.
Okay. Do I come with them with the contract?
If you want to create your own contract, you can view our model contracts on our website.
Okay.
And you can use that as your template.
Okay.
Or if they provide you with a written contract, then that's totally fine too. Just make sure that the elements that we mentioned earlier are in the contract. So like the name of both the hiring party and yourself, the itemization or breakdown of the work that you'll be doing, the value of the work, and the pay date.
Okay.
Also, another thing, invoices can also technically constitute as a contract because they contain those same elements. Names of the hiring parties, itemization of the work, value of the work, and the pay date. Okay, so if you don't want to go the contract route, or if you feel like they might give you a hard time, then what you can do is you can start invoicing them. Just make sure that in those invoices, you contain those elements.
Okay.
Okay? Okay, so, again, and this is just to make sure that all the parties involved are identified. So you want to make sure you have the name of the person that you're negotiating with. You want to have the name of the business, if it's a business, a contact person, their address, their phone, email address. We encourage everybody to do your research on the hiring party before you initiate any kind of work or you engage in, you sign any contract. Do your research. If you see that this hiring party has a history of bad practices or they have a history of bad reviews, you might want to weigh your options and say, okay, if I'm going to go work with them, then I've got to make sure that I'm protected, that I'm covered, and then I have everything in writing. Okay, this is the scope of the work. So, I don't know if anybody here has worked with they call them scope creeps, where you have a hiring party who will constantly change the nature of the work throughout the entire time that you're doing the work. So this section right here allows you to describe the scope of the work, and again, this is going to be the rate or the payment for the work that you're doing. So you want to make sure that the work that you're going to do is, if you're putting it in, or put it in writing, it's as detailed as possible. So that way, in the future, if they say, "Oh well, we didn't agree to this," well, if you look on the contract, you see the scope of services, the scope of the work. This was in the contract, and therefore you have to honor that. Okay. Okay. Again, you want to list the total amount that you're going to be paid. You want to indicate the method that they're going to pay you, whether it's cash, check, or any other method that they use. You want to make sure you indicate that in your written contract, the date or the time that they're going to pay you. Okay, and these are some optional clauses that you can include in your contract. So let's say if you know that this hiring party has a history of paying late, and in your written contract, you might want to include a disclaimer or a clause that says, for every day late or for every week that the payment is late, I will be charging a late fee. And then you can, at your discretion, list what the percentage will be, but you also want to make sure that it's reasonable. Right? You don't want to say, okay, well, for every day late, I'm charging you a 50% late fee. But they'll look at it and they say, well, we're not going to sign this. We don't agree to this. So, you just want to make sure that it's a reasonable rate. Verification, modification, or termination of the agreement. If you feel that the hiring party at some point might want to terminate the work, or if you feel like they might not honor their part of the contract, you want to include that clause in the contract just to make sure that they don't try to get out of not paying you for not working out the contract. Choice of law. Well, New York State law. You want to list that any disputes that arise under this agreement is going to be governed by New York State law. So that's basically saying, okay, well, if we do have an issue, we can go to court, and under New York State law, we're going to have to follow their procedures. Ownership. I know in certain industries, like you have to intellectual property.
What's the name of this contract?
Well, no, this is just a model contract. This is our template that we have on our website that you can use to create your own contract.
What do you call it?
Freelancer contract.
Freelancer contract.
Yeah. I mean,
there's no like creative, or is it specific?
No, you can tailor it to the work that you do, your industry, your profession. It doesn't have to be like this isn't a general contract that applies to every freelance worker in every industry. No, you can use this to tailor it to the work that you're doing. But this is just a template to give you an idea of how to construct your contract and what are the key clauses or elements that you need to include in a contract.
I see.
Yeah, but no, you can tailor it to to what it is that you do. And so again, so ownership, have you guys heard intellectual property? Does that ring a bell? You guys heard that intellectual property? Like I know in certain industries, you have to sign your rights to the work that you do to the hiring party. So this clause allows you to either assign them the entire rights to the work, or let's say if you have a copyright or a patent for a specific work or method or product that you provide, you can include that and say, well, I can loan you the rights to this, let's say, product, but I'm the owner of these rights, and after this certain time period, then I regain those rights. So I'm loaning it out to you temporarily for you to profit off of it, but ultimately, once that time expires, those rights now belong to me. And if you try to profit under these products or services, well, then they're breaching copyright. That's copyright patent infringement, and you can take action against them for that too. You can indicate whether the information is confidential, limitations on liabilities, so what you're responsible for, what you're not responsible or liable for when you're doing the work. Is something that you might want to indicate to the contract. Yeah, that's pretty much it. And you want to make sure that the hiring party signs it, because they can say, oh yeah, we agreed to the contract. They'll never sign it. So now when you try to dispute, say, well, but we never signed this contract, so we don't know what you're talking about. You want to make sure that they sign the contract and you have a copy of it. Okay? And yeah, so this is our model contracts, and you can view them through our website, nyc.gov/DCA/workers.
This Freelancers and Free Act, these laws you've been speaking of, are these limited to New York State?
Yeah, so, and it's a New York City law. It applies to, or under the law, as long as one of the parties involved either resides in New York City or operates out of New York City full time, then the law is applicable to them. So like, let's say for example, you're a journalist, you live in Tennessee, but you worked remotely for a company that's headquartered here in New York City. So under this law, if they do violate your rights under the freelance law, then yeah, you have a right to file a complaint because the hiring party is stationed here in New York City. So as long as one of the hiring parties is stationed in New York City, then the law applies to you. Like I had a freelancer several months back who lives in Louisiana, did work for CNN, but the work that they did was done in Alabama. Now, they were protected under this law because CNN is headquartered in Lower Manhattan. So the law applies to them. So as long as one of the individuals involved resides or operates out of New York City, then the law applies to you.
You mentioned earlier you have to establish an LLC to be considered a freelancer?
No. So no, if you are or if you do operate as an LLC, it has to be a single person LLC. So it cannot be. Let's say you operate as Company X LLC, but you have a partner. Under the freelance law, then you're not a freelance worker. It has to be a single person, an individual. You can operate either as an LLC, S corp, but as long as it's a single person.
What kind of tax form should we make sure we're signing?
So generally, freelance workers sign a 1099. However, in a lot of cases, like they'll get a 1099 for working with this company, but then when they work with this company, they'll sign it or they'll fill out a W-2 form. I mean, technically that makes them an employee, but because of how the hiring party operates, to avoid any issues with payment, they'll agree to receiving a W-2 form or being paid as a W-2 worker. But generally, 1099s are the forms that freelancers fill out. Does that answer?
Yeah, I signed a W-2, but I just wasn't sure if that was the right one.
Mm-hmm. Well, and again, it's common. It's not uncommon. It's pretty common. But the tricky thing with signing a W-2 is, well, for one, you're basically being paid as a traditional worker. So the taxes, the hiring party deducts the taxes when you're paid as a W-2 worker. And they might also say, well, if we're paying you as a W-2 worker, you're not a freelancer, you're an employee. So that's just something that you want to watch out for. But it's not uncommon. Freelance individuals that operate as full-time freelancers, depending on the hiring party, they either sign a 1099 or they'll sign a W-2. It's not uncommon. Any questions? Good. All right, well, again, thank you all for having us. We do apologize for our tardiness. But if you do have any questions or any additional questions for us, if you want to know a little bit more about the law or what other services we do provide, don't hesitate to reach out to us. You have cards? Yeah. So my colleague Alberto is going to hand you our cards, and if you want to reach out to us, please feel free. Any questions you may have, or even contract questions, give us a call. Thomas, thank you. I didn't mean to put you on the spot.
Yeah, no problem.
And anybody, if you could fill out your card and take them to us, that would